Okay, good afternoon, everybody. My name is Tim Barker. I'm District Attorney of York County, and we are here before you today to go ahead and discuss the report of the York County Investigating Grand Jury, which was convened and had been going through a full investigation into the death of Haywood Dixon Jr. He had died on July 7th of 2023 in York County Prison, and over the last couple of years, the investigating grand jury had been reviewing the circumstances surrounding his death. And at the completion of the investigation, a report was prepared and now has been filed of record, and the redacted report is available for individuals in the community to obtain. And so at this point in time, we're going to go ahead and discuss a little bit about what the results were of those findings and some of the circumstances surrounding why we proceeded in this particular fashion. Before we begin, there are individuals that I do want to thank. Of course, you see to my right, you see the Pennsylvania State Police, and Trooper Van Kuren was the lead investigator on this particular matter. He conducted a very thorough investigation in conjunction with the Pennsylvania State Police and with our office as well. Our county detectives also were very involved in investigating this matter, and also the Chief Deputy Prosecutor, Caitlin Gross, who runs our grand jury. She is in trial right now, unable to be with us, but we appreciate her hard work. Also that of Lieutenant Jeffrey Rainier, who is our lieutenant in our office and assisted greatly with aspects of this investigation. Also, you have to my left, you have John Wetzel. You'll remember him as being the Secretary for the Department of Corrections. He's involved in extensive consulting on policing, and he also was retained as an expert witness in this particular case to go ahead and analyze, from being an expert in corrections, different aspects of what occurred that led up to the death of Haywood Dixon Jr., as well as any kind of recommendations and evaluations on use of force and the quality of medical care that had existed in this particular case. What I want to do is, if we can turn to the first slide, and we do have some slides to help us out today with some order and structure. The report in this matter was approximately, if I recall correctly, 157 pages. That's the redacted report. The unredacted report was even longer. Clearly, I'm not going to go ahead and read 157 pages to you, and having the use of a PowerPoint slide will help us with some organization of key findings as you then go through and review the work for yourselves. But it's always important to begin with, what is the definition and purpose of an investigative grand jury report? Because that's the scope of why we were here and what we are doing. And when you see the definition, you'll notice highlighted the second portion. Proposing recommendations for legislative, executive, or administrative action in the public interest based upon stated findings. That is the purpose of why a report was created. A report must have that as its purpose and focus. You have essentially your statement of facts, the findings that the investigative grand jury made, followed then by recommendations. This is not prepared for purposes of making accusations of non-criminal activity. And I'm going to get to that in a moment when we talk about some of the things that had to be done regarding redactions. First, though, we want to talk about some issues in confronting this matter that the grand jury had to go ahead and determine and analyze. And when we began convening the investigative grand jury and putting Haywood Dixon Jr.'s death before them, there were some matters that we knew were going to need to be discussed. And this began through a discussion between then Coroner Pam Gay, based upon the findings in the autopsy report by Dr. Ramin Starling-Roney, and with the Pennsylvania State Police. There were questions left undetermined, most importantly, a manner of death. And these questions gave rise to other questions in figuring out how should we investigate them and how should we review them. And so that resulted in some issues that by their very nature were going to have to be resolved by the investigating grand jury. So as we see on the screen, number one, what was the known scope and nature of Mr. Dixon's health issues while committed to York County Prison? Number two, did York County Prison and contract provider number one, did their staff follow all applicable policies and procedures to provide appropriate care to Mr. Dixon? Now you'll notice already there's a reference, contract provider number one. That's the first example of a redaction. And I'm going to explain further why we used redactions and how we used redactions in a moment. Number three was the use of force by corrections officers, including taser and emergency restraint chair, appropriate under the known circumstances. Four, to what extent was the use of force by corrections officers a factor in Mr. Dixon's death? Five, did any York County Prison personnel commit abusive or assaultive acts against Mr. Dixon up to and including any criminal behavior towards Mr. Dixon? Six, was the medical care offered to Mr. Dixon by the nurse number one and nurse number two appropriate under the known circumstances and medical history for Mr. Dixon? Again, you see a reference to redactions. To what extent was any failure to render medical care by nurse number one a factor in Mr. Dixon's death? Did any contract provider number one personnel deprive Mr. Dixon through act or omission of potentially life-saving medical care up to and including any criminal behavior towards Mr. Dixon? What, if anything, could have been done to avoid Mr. Dixon's death? Are any policy changes required under York County Prison or contract provider number one or any other medical provider contracted with York County Prison to avoid this from occurring in the future? Now, through the scope of this nearly 2-year process that we had undertaken with the investigating grand jury, a lot of information was provided for their review and for their consideration in preparing a report. We heard the testimony of over 30 witnesses, including individuals and law enforcement who were with Mr. Dixon at the time of his arrest and of his processing, York County Prison staff, contract provider number one staff, York County Coroner's Office members, the lead investigator from Pennsylvania State Police, and experts in forensic pathology and corrections. Over 55 exhibits, including body-worn camera footage, surveillance video footage from York County Prison, reports prepared by corrections officers and medical personnel, medical records concerning Mr. Dixon, and policies and procedures from York County Prison and contract provider number one that were relevant to this particular case. Information concerning the report generated by a prior York County investigating grand jury that examined the circumstances surrounding the April 9th, 2018 death of Everett Palmer Jr., containing considerations that were important to revisit to determine if YCP implemented any overlapping Palmer report recommendations. And if you'll recall correctly, back in 2021, we were all present together discussing the results of that investigative grand jury report. And this report should be thought of in some respects as a companion when we look at and analyze how York County Prison, how the structures in place for what we do in terms of corrections and medical providers, the medical care that is given to inmates, and how we view these things legislatively, looking at that continuum, how they work together, and is there progress in this area specifically focused on York County. Some of the things that were overlapping considerations with the Palmer Report recommendations involved de-escalation techniques. That was a focus of both reports. Crisis intervention team training, and we've had extensive discussion about the role of crisis intervention team training in York County and in the York County Prison. And finally, use of force matters. And in this case, the continuum of use of force is something that is a very important part of review and recommendations. Now, we mentioned about redactions. Pennsylvania, you have a constitutional right of reputation. This is guaranteed in Article 1, Section 1. And quite frankly, this right of reputation is as paramount as the right to life, liberty, or property. And this has been held this way by our Pennsylvania Supreme Court. And this is very critical when you're talking about a grand jury report. Starting with the 40th statewide investigating grand jury that we all remember being the sexual abuse allegations towards Catholic dioceses and Catholic priests conducted by the Attorney General's office, there began a series of cases talking about the scope of this right of reputation and the requirements for potential challenges by individuals, redactions of information, and also, depending upon the facts and circumstances, the potential mandatory sealing of an entire report. Subsequent to that, we had two such circumstances. The primary issue was that the facts and circumstances and the underlying nature of the report was not within the confines of producing policy change recommendations. That's one of the reasons why they specifically noted, and we do know that having an in-depth factual finding does give the opportunity for truth to be seen and revealed by Haywood Dixon Jr.'s family. And we are very appreciative that that occurs. That, however, is not the reason and purpose for a report. Statutorily, it must be within those strict confines of essentially recommendations of policy change. However, one of the things that also came out of these cases, even as recently as the 30th investigating grand jury from Philadelphia that came out in 2024, is also the need for challenge and the further need for redaction. The purpose of a report can never be for shaming individuals. It is not for purpose of embarrassment. It is also not for purpose of negatively impacting one's reputation. If you cannot bring a criminal charge, you do not do a report so that someone can go ahead and feel like they were charged in the court of public opinion. That is not the purpose of a report. To go ahead and deeply honor this right of reputation from Article 1, Section 1, and to honor the case law and following what the Supreme Court has stated, we have redacted the names of all but 4 individuals from this report. Those individuals are our former warden, Adam Ogle. They are John Wetzel. They are also Coroner Pam Gay, and finally, Dr. Ramin Starling-Roney. Now, we put forth, and of course have no problem with the assertion that the state police and through Travis Van Kuren as the lead investigator who those individuals were, and their names would also have not been subject to redaction if there would have been more purpose for them to be in the report. But for any other individual, be they the original arresting officers, the corrections officers, the individuals that worked for the contracted provider, even that agency itself, calling it contracted provider, all of that is done with the utmost care so that no one can claim that this report is anything other than pure within the confines of the legislative purpose. That also includes references to an individual solely called consultant number one. We also attempt to use gender-neutral terms throughout, so nothing could be read in that way, referring constantly to they, their, and them. And that is also intentionally done so that there can be no attack on the propriety of this report and the purpose behind it. Finally, there will be a section in this report where we talk about law and conclusions, where similar to the report concerning Everett Palmer's death, where there is a statement from the York County District Attorney's Office discussing the law and the reason why no presentment was requested. And we'll talk more about that in a couple of slides. That section is heavily redacted. The reason for that is because that was an explanation of law and the course of which we needed to be on to the investigating grand jury, that they needed to know and how we operated within our ethical scope. In doing so, there are specific discussions of facts reported by the investigating grand jury and their interplay with law as deemed by us as the prosecution, and why we were not making a recommendation for a presentment. Those materials, while critical to an unredacted report and to the knowledge that such information was provided to the investigating grand jury, they also could be twisted and turned into a purpose for which they were not intended. And that would be, again, making accusation in the public sphere against one or more individuals that would be in a nature of accusing someone of non-criminal activity, but would cause embarrassment or impact to their right of reputation. So accordingly, we redacted large portions in that report. And I cannot discuss, as a matter of law, any of the redactions. Anything that is redacted, I cannot do anything other than state it is redacted and refer to redacted names. That is it. But with that said, the report is extremely thorough, and you are able to tell the finding of facts that the investigating grand jury made and have submitted publicly for everyone's consideration. So as part of the report, pardon me, we did something to lead into a full description of facts from the point in time when Mr. Dixon was in York County Prison. We did a timeline of events. And then following that timeline of events, the investigating grand jury reported the facts surrounding the timeline in full. The timeline of events we began at the initial medical intake on July 5th, 2023 at 6:05 p.m. because that's the moment in time where initial medical conditions were discussed and discovered. So we have, as part of this timeline, underlying conditions that had existed within Mr. Haywood Dixon. Those included diabetes, those included high blood pressure, those included obesity. These risk factors and aspects that involve cardiovascular questions were part of the medical intake, and also began a course of different types of medical care that would occur, such as testing for blood sugar levels, which becomes important as we proceed through. Also reported and solely being used for the purpose of medical consideration were substance use disorder issues, which include use of methamphetamines, of stimulants, and also of marijuana, and also any other correlating mental health issues are all part of the screening, and they're all part of the determinations for what course of treatment should occur. When we fast forward to July 6th of 2023 at 8 p.m., we now have a blood sugar check that is to occur. And I will apologize if at times my voice and my sound is a little rough. I get impacted by the horrendously cold weather, just like everybody else does. And when you're talking nonstop while going through that, sometimes you need to go ahead and take a pause. At 8 p.m., this request is made. He refuses to complete the check for his blood sugar levels. And additionally, he was refusing to sign a refusal. He was brought to the medical area to execute the refusal, and Mr. Dixon, as it shows in the complete report, he did not wish to comply with that, instead wanting to just go back to his cell, and was laying on the bench in medical. There became a point where, to try to go back, he began yelling at staff, and that all was occurring as well with him expressing that he didn't feel well, was dizzy, needed water, and he stated he can't sit up or walk. He was not provided water at that time, was told instead that he would receive water later, and an exchange began between he and nurse number one. Nurse number one stated in reply at one point, "You feel well enough to yell at me." And there was an escalation. Nurse number one testified before the grand jury that this was not typical of her exchanges with inmates. And she did not know at that time what her reason was for engaging in that way of being irritated. But at that point, as we see, Dixon is then escorted to Seg A4 for placement on medical observation until seen by a provider. Now, providers in this context, they are the individuals who are doctors or physician's assistants. There are providers that are always on call, but they also come into the system. So that is not to be confused when we refer to contracted provider, your contract provider number one, with the general term provider. That's going to be an on-call doctor or a physician that comes in or a physician's assistant. Now, one of the things that is unclear is whether or not a call was made to the on-call provider at that point. The documents show, the records show from nurse number one, that nurse number one did in fact contact a provider. Provider number one did not remember being contacted, did not recall communicating about this. Giving all benefit of the doubt to what was contained in the record, it is construed that the provider was contacted and did clear for being placed on medical observation Mr. Dixon at that point. One of the items that Mr. Wetzel also referred to in his expert evaluation with the refusal and the medical issues that Mr. Dixon had, that having medical observation is something that can be appropriate in that circumstance. However, as Mr. Wetzel opined, there was a lack of thorough medical evaluation that occurred in medical at that point. That should have occurred before, in his expert opinion, in corrections and correction procedures. That should have occurred prior to placing somebody in medical observation. You did not have the thoroughness of the medical evaluation, and additionally, there was no de-escalation at that point, which goes next into what occurred in going over to Seg A4. Lieutenant number 1 contacts SORT. SORT, as you see, is a specialty team within the prison that is primarily responsible for high-risk extraction. However, and is a subject of the recommendations, SORT also gets contacted to engage in tasks that otherwise could and should be accomplished by corrections officers. The lieutenant called in SORT, and CO number 1 responded as part of the SORT team. CO number 1 did not have a lot of experience on SORT as of that point. His approximate time period of being on SORT roughly is going to be around 5 to 6 months. He had been employed for approximately 5 months and a couple of weeks prior to being on SORT. That technically is before when, pursuant to policy, an individual would normally be placed on SORT. However, there are exceptions that can be created to allowing an individual to come on early. That was given to CO number 1. CO number 1 responds, and at that point in time, no one, be they medical, be they corrections officers, are engaging in de-escalation techniques. Mr. Dixon is taken to Seg A4, and while he's in there, he's asked to remove his clothing to comply with the strip search while being put into his cell in Seg A. This is at 9:17 p.m. A strip search is a standard part of what occurs when you move cells like this. That is standard part of policy to protect against weapons or contraband in this kind of movement. However, in doing this, there was a lack of de-escalation techniques that occurred. No one in the cell and that was assisting engaged in de-escalation techniques. Specifically, they were talking over each other, the different corrections officers, which causes confusion and causes an inability to respond to commands and requests. And again, all of these extra details are contained within the redacted report. During the course of this request, Mr. Dixon is specifically requested to take off his shoes. He responds that he cannot comply with this and take his shoes off. He states that he cannot take his shoes off and that the reason why is because he did not feel well. And being unable to do so, Mr. Dixon couldn't bend over. There are continued exchanges between the COs and Mr. Dixon, and the COs again are communicating over top of each other. One CO, CO number 2, has his hand on Mr. Dixon in a non-aggressive, non-force compliant method, just has his hand at his arm. CO number 1, the SORT member, meanwhile, has drawn their taser out. They're pointing their taser at Mr. Dixon, and in pointing their taser at Mr. Dixon, is now saying comply, comply, and is showing clear indication that Mr. Dixon is going to be tased if there is non-compliance. CO number 1 then tases Mr. Dixon. Mr. Dixon turned slightly, and at the slight turn, that is when CO number 1 tased Mr. Dixon. CO number 2 was obviously surprised by this. You can tell through looking at the video and the further commentary and information provided by CO number 2. There was no yelling of tase, tase, tase to alert that the taser was going to be deployed. In fact, at that point in time, CO number 2 still had their hand on Mr. Dixon when the taser made contact with Mr. Dixon. Mr. Dixon went to the ground. Mr. Dixon was at that point in time having difficulty breathing. Mr. Dixon was rolled over, was questioning why was he being tased. He didn't do anything. He was not showing hostility. And at that point, Mr. Dixon is then led out of the Seg A4 cell unit to be placed in an ERC in a emergency restraint chair. That's occurring at 9:20 p.m. with the tasing, 9:25 p.m. now with the ERC. And as part of being placed in the ERC in the emergency restraint chair, a spit hood was also put over top of Mr. Dixon. There was no attempt again at this point for de-escalation or to see if Mr. Dixon could go over safely to medical. Per policy that was being conducted at that point in time, essentially the use of an ERC was almost an automatic following of the taser deployment and going to medical. At 9:26 p.m. now, Mr. Dixon is transported back to medical and is being evaluated post-use of force. This evaluation is being conducted, I should say, by nurse number 1. There is a specific medical use of force policy that contracted provider number 1 had for every facility that contract provider number 1 provided medical care in. In that use of force policy, which as a planned use of force, and this qualified for the policy, that requires certain things to be done in the course of treatment. It requires a full examination of an individual's body for taser probe marks. It requires a full and complete checking of vital signs. It requires also an EKG be conducted, and it requires contacting the on-call provider for follow-up with medical professionals to determine a future course of action. This policy, as stated in the investigating grand jury report, and as the evidence continued to reveal, was unknown by numerous individuals. First, this policy was not known by Warden Adam Ogle because this all facilities policy was not included as part of the York County Prison specific policy. Within the medical care system, there were specific medical policies that were established and implemented based upon an individual prison's, or technical term really should be jail when you're talking the county level, because of the temporary nature of how individuals stay in the facility. And a prison, in terms of corrections terminology. A prison is really a state correctional institution. But your varying sizes of jails like York County Prison, they get different types of facility-specific policies that are going to be followed where there can be modification. But if you are an all facilities policy, you were to be followed everywhere. The all facilities policies were not given to and placed in York County Prison. This caused Warden Ogle to not be aware that an EKG was required following every tasing. After Mr. Dixon's death, Warden Ogle specifically lobbied the contract provider to have an EKG be performed after every tasing incident, not knowing that that already was the policy. And those that were serving York County Prison locally didn't realize as well, because they agreed to implement that as a change in policy in November of 2023. Furthermore, even though there are to be tests and continuing education conducted by the contract provider with their staff, both nurse number 1 and nurse number 2 did not recall hearing about the policy or recognize the policy. Adding to further confusion, administrator number 1, concerning the mandatory contact for EKG and for provider, because it says in the policy, shall. It's not discretionary, it's mandatory. Administrator number 1 recognized that such may not be occurring in the discretion of the people that were working in the medical areas, stating that policy could be worded better. So there's confusion that is noted through the course of the grand jury report regarding the state of what is required as part of the medical policies and protocols when an individual is brought in post-tasing for a medical examination. In this particular case, the vital signs that were checked, there was a temperature check done via forehead, but through the spit hood. There was a pulse check, and there was also a blood pressure check. That was conducted while Mr. Dixon was still restrained in the ERC. The check for probe marks, there was a check with regards to the back area of Mr. Dixon that was able to be conducted by him leaning forward, but no check was conducted of his legs for the other probe marks because he was still in the emergency restraint chair. There was no EKG conducted. There was no call to the on-call provider. Additionally, there's a separate policy regarding emergency restraint policy, where medical is supposed to do a check to see if the individual is healthy enough to remain in an emergency restraint chair. And it becomes, barring certain specific security concerns, a medical decision regarding remaining in an emergency restraint chair. There was no check to see if Mr. Dixon should remain in an emergency restraint chair. And one of the dangers with regards to restraint, similar to what can occur with tasing, is the impact on the body. If there are underlying conditions, especially unknown underlying conditions, there can be medical complication. At this point in time, in medical, there's a decision made for Mr. Dixon to be sent to what's called Seg B. Seg B is an area where one goes to for mental health observation. And in this case, the decision to determine whether Mr. Dixon should go to mental health observation was made by nurse number 1, who nurse number 1 is an LPN, as mentioned in the report, and we'll come back to that later, is not an RN, and did so without contacting a provider. There was no further consult with a mental health professional. And the basis was Mr. Dixon at this point was crying and emotional. Mr. Dixon kept stating that he did not feel well, kept stating that he just wanted to lie down. And Mr. Dixon at that point stopped talking to anyone. In the evaluation to determination of why Mr. Dixon was doing this and why these behaviors were occurring from Mr. Dixon, there was never a discussion or an attempt to analyze what Mr. Dixon meant when he was saying he did not feel well. At this point, Mr. Dixon is now taken to Seg B. He's transported back there. He's in Seg B 15, and he's placed on SP2. That's a specific status of observation. It's not continuous observation. It's 15-minute rotation observation. Once he was in his cell, he sat on the floor undressed and crying. This is at 9:37 p.m. At 9:56 p.m., nurse number 1, along with COs, goes back to his cell now at Seg B. And Dixon was stating that he was having difficulty breathing. He also indicated he was thirsty. Nurse number 1 informed Dixon that the reason why he did not have a cup for water is because he was at Seg B at that point. And at the end of their conversation, Mr. Dixon began to yell generally towards nurse number 1 and towards all staff that was there at that point. There was no further medical action taken at that point in time. At 10:14 p.m., we now have Dixon being observed. He's observed breathing heavily in his cell by COs. They're now taking notice that he's breathing heavily at this point. Following further rotations, COs again come to Mr. Dixon's cell, and at this point, they hear him having labored breathing and saying that he could not breathe. This is at 10:40 p.m. The COs now go into the cell and they check on Mr. Dixon, and he's covered in sweat. He's continuing to have labored breathing. He's stating he could not breathe and was asking for help. Mr. Dixon was specifically telling COs that he was having trouble breathing and that he could not move. At this point, 10:46 p.m., CO number 2 asks Sergeant number 1 to relay this information to medical. Sergeant number 1 does go to the medical area to report the CO's concerns about Mr. Dixon's medical condition and reports that to nurse number 1. This is at 10:48 p.m. Nurse number 1, who remains the charge nurse on duty, the LPN, advises Sergeant number 1 that Mr. Dixon was an a-hole and that the incoming third shift RN could take care of Dixon. Sergeant number 1 returns to Seg B and relays this information to CO number 2. This all occurs between 10:48 and 10:50 p.m. Now, in terms of this interaction, something that was very important to note by the grand jury because you're going ahead and you're noting the completeness of what occurred. In the initial statement made following Mr. Dixon's death by Sergeant Number 1 in Sergeant Number 1's report, Sergeant Number 1 did not include this exchange with Nurse Number 1. In Sergeant Number 1's second report, however, Sergeant Number 1 did include this exchange, as well as Sergeant Number 1 did include his conversation regarding this with Trooper Travis Van Kuren, the lead investigator in the case. And this is specifically noted in the investigating grand jury report. The investigating grand jury also noted that Nurse Number 1 testified that they could not recall saying to Sergeant Number 1 that Mr. Dixon was an a-hole and that they refused to check on Mr. Dixon, instead leaving it to the next shift. But we were able to corroborate through evidence that was presented to the investigating grand jury, and they so found that there was video footage of medical from prison surveillance without audio that showed the interaction between Sergeant Number 1 and Nurse Number 1 in medical. And you see Sergeant Number 1 come into medical. You see an exchange of conversation, a short one with Nurse Number 1. You see the response back of Nurse Number 1, and then you see Sergeant Number 1 return back over towards Seg B, consistent with what was reported by Sergeant Number 1. This occurs between 10:48 p.m. and 10:50 p.m. when Sergeant Number 1 responds back to medical. Again, it's in the interest of fairness and completeness that you show all sides and all signs of what was occurring in terms of the recollections and the reporting of individuals involved in this particular matter. At 10:52 p.m., CO Number 2, who was informed about what the exchange was by Sergeant Number 1, CO Number 2 then personally went to medical to express concerns about Mr. Dixon's medical condition. The incoming RN, Nurse Number 2, had advised CO Number 2 that Nurse Number 2 wanted to see Dixon in medical to have an EKG performed. At 10:53 p.m., CO Number 2 returns to Dixon's cell in Seg B. Nurse Number 2, who was conducting aspects of rounds, then responds to Mr. Dixon's cell at 11:02 p.m. Now, one of the things that occurred at the time when CO Number 2 goes to medical, and again, this is captured in video, but no audio, but corroborates what Sergeant Number 2 stated, what CO Number 2 stated, and also what Nurse Number 2 stated, as Nurse Number 1 did not have recollection of these events beyond knowing that Nurse Number 1 communicated with Nurse Number 2. What had happened was when CO Number 2 approaches, mentions about Mr. Dixon, Nurse Number 1 states to Nurse Number 2, "This is the individual that I wanted to talk to you about." And there begins to be an exchange of information regarding Mr. Dixon. However, this exchange of information was not lengthy. It was relatively brief, and it was not in the perception of Nurse Number 2 rising to an emergent situation. Nurse Number 2, after giving instruction that they wanted to go ahead and see Mr. Dixon for an EKG, Nurse Number 2 continued working on Nurse Number 2's duties as being the coming on shift charge nurse, and then responds at 11:02 p.m. Again, nurse number 2 wants to see Mr. Dixon in medical to do the EKG. At 11:07 p.m., COs attempt to take Mr. Dixon to medical to be evaluated. Mr. Dixon was unable to get up, get dressed, or assist in getting into a wheelchair. Mr. Dixon falls to the ground and COs immediately declare a medical emergency and start CPR. This is at 11:15 p.m. EMS arrive at 11:30 p.m. and they begin to take charge. Additionally, when the medical emergency is declared, a medical emergency requires essentially medical personnel. They must respond to where the emergency is and immediately take over medical response. The first to arrive was nurse number 1. Nurse number 1 began medical intervention, began CPR interventions. Nurse number 2 then arrived, and nurse number 2 noted that Mr. Dixon's pupils looked like, as nurse number 2 put it, they were blown out. And nurse number 2 then took over performing CPR, and they continued to conduct their techniques until EMS arrived. Medical treatment was continued. Contact was occurring with York Hospital until finally life-saving medical treatment was deemed to be unsuccessful. And at 12:06 a.m., Mr. Dixon was pronounced dead. Now, part of this particular matter involved then the coroner's office responding and examining what occurred and having a forensic autopsy be performed by a forensic pathologist. And Dr. Starling Roney had determined Mr. Dixon's cause of death was bilateral pulmonary thromboemboli in the setting of incarceration and restraint, with contributory factors of obesity, an enlarged heart, and diabetes. One of the things that also was noted is that there was no evidence of any controlled substance in Mr. Dixon. This is not a situation where, if you recall in Everett Palmer's report, that had complications from methamphetamine toxicity. There is no aspect of a drug at play in this particular case in terms of any acute impact of the consumption and ingestion of a drug. The cause of death being what it was and being in the course, as noted, of incarceration and restraint, given the review of all the other video materials and information provided, led to the question regarding the manner of death. And the manner of death, we will state at this point in time, we do not reach that conclusion as a DA's office. The grand jury does not reach that conclusion. A copy of the redacted report has now been provided to our coroner, Tanya Zeck, for Coroner Zeck's review to make a determination now regarding manner of death, to see if one can be reached at this point. One of the aspects, though, that Dr. Starling Roney noted was the lack of medical care that had occurred, and the fact that right up to when nurse number 1 did not leave medical to attend to Mr. Dixon at the request of Sergeant number 1, this time that had passed, that has an impact on survivability. Of course, the overall scope of time of medical care and medical observation has an impact on survivability. Dr. Starling Roney specifically noted that blood clots in the lungs are very serious, and he said that most likely this began as deep vein thrombosis. And because of deep vein thrombosis, when you have restraint and when you have the events that had occurred, including tasing, if you have deep vein thrombosis, this impact may play a role in whether or not the deep vein thrombosis does move. And I'm giving a general paraphrasing of what is stated in the report and why this is important. Dr. Sterling Roney noted that he could not say with 100% certainty if Mr. Dixon would have survived if he received treatment between 13 to 15 minutes prior to when EMS was called, when Sergeant number 1 approached to nurse number 1. However, he noted that any delay in medical treatment, that will have complications. And if you do not delay medical treatment, that can allow for medical therapies that could break up clots and save Mr. Dixon, or at least help in the situation, so he is not imminently going to pass. If medical treatment had been provided earlier at the point in time of the taser and the ERC usage, that would have increased the opportunity for survival. And with prompt care, Mr. Dixon's condition was survivable. This conclusion and this analysis, and there is further testimony contained within the report by Coroner Gay regarding her experience as an RN and knowledge that these particular medical scenarios can be survivable with proper medical treatment. This was a factor that needed to be considered as part of a legal analysis and conclusion. For the legal analysis and conclusion, as noted before, we had to redact a lot of information out of that section because that was our commentary to the investigating grand jury as to why we did not give a presentment. We specifically were analyzing charges such as involuntary manslaughter. Involuntary manslaughter carries with it two primary aspects. One is a mental state that is of recklessness. There's also the term gross negligence, but under the case law, that is deemed to be the same thing as recklessness. And what is recklessness? That is a conscious disregard of a known and unjustifiable risk that the harm will happen, and it is a gross deviation from what a reasonable person would do if you did not acknowledge, if you ignored that risk. In this particular matter, no individual was able to be deemed to have acted recklessly, to have shown that conscious disregard. In this aspect, there was a lot of information provided to the investigating grand jury explaining why, so they knew. I cannot go into those details because that is redacted, and to ensure that no one would be able to read into any subject of any such evaluation or analysis. A second prong is causation. You must be a direct and substantial causation. There were actions that could demonstrate that individual or individuals did impact Mr. Dixon with regards to being a causal factor in death. A direct and substantial cause by either act or omission. And that doing so was a gross deviation, did meet that standard. However, nothing could meet, again, the conscious disregard prong of the harm that could result, and that it was a substantial and unjustifiable risk of the harm. So accordingly, even though there may have been for an individual or individuals causation met based upon act or omission. There was not the mental intent that could be met. In the report, you'll see an analysis also of criminal negligence and how some jurisdictions have something called criminally negligent homicide. That is not something our jurisdiction has and is not for consideration by the investigating grand jury. But we will discuss that in one moment further when we talk about the recommendations of the York County Investigating Grand Jury. There are 12 recommendations. Number one, YCP should continue its efforts to change the culture within its facilities. One of the aspects that was presented and commented on by the investigating grand jury was what the culture was in York County Prison. Consultant number one had implemented some recommendations and designs for how different members of York County Prison, especially SORT, should carry out their duties. Consultant number one relied greatly on the use of taser, and taser usage had increased. Warden Ogle did not agree with the increase in taser usage and did not feel that that should be used as part of compliance, but was being used as part of compliance. Consultant number one was no longer working with York County or York County Prison by early 2023, prior to Mr. Dixon's death. However, this culture of use of taser, this culture of using it for compliance purposes, this culture of not having increased empathy was still existing, even though it was being worked on, and there was the desire to have that be removed by Warden Ogle and by other management within York County Prison. And that includes the SORT Commander number one, who began to work on these aspects as well. The investigating grand jury recommended that we must continue to work on breaking that culture and taking YCP away from the influence of consultant number one's methodology, and that will increase compliance while decreasing use of force. And we do know that they will go hand in hand. How do we know that? We know that from data. Just to mention that the use of taser had decreased dramatically, and it was presented to the investigating grand jury, and the investigating grand jury included that in its report. In 2021, there were 11 incidents of taser use. There were 23 incidents of taser use in 2022. There were 20 incidents of taser use in 2023. And there were 2 incidents of taser use in 2024. When it came to high-risk extraction, which is called HIRE for shorthand, from July of 2024 through April of 2025, out of 39 high-risk extractions, 39 high-risk extractions did not use force, compared with 16 that did use force. And only 1 out of 22 high-risk extractions used force from January through April of 2025. So already with the shifts that were occurring, as presented to the investigating grand jury, we were seeing decreases in taser usage and decreases of use of force in high-risk extractions, showing that the two do work together, do go hand in hand. And what is responsible for working in that way? It is the aspect of de-escalation and utilizing other techniques in these circumstances. Number two, YCP should change its structure to ensure that a clear chain of command exists at all times. It's commented extensively by our expert witness, by John Wetzel. There were obvious issues regarding chain of command. The lieutenant number one, was not in charge. Yet lieutenant number one was the ranking person in charge. When SORT was called in, SORT began to take control. But SORT did not have rank, specifically CO number one did not have rank. The questions arose then, who actually is in command? There needs to be clear chain of commands for your lieutenants, your sergeants, your line COs. They must all know in a given area who is actually in charge. Now, Warden Ogle testified to the fact that already in 2025, there was the beginning work on a restructuring within York County Prison, the details of which could not be disclosed to the investigating grand jury, and the details of which at some point within the confines of safety for prison personnel will be disclosed, has been worked on, and as we are here today, I can state definitively has gone very, very far to true completion and initiation. All of which was being done independently from the grand jury due to recognition that was existing by both YCP leadership and the prison board regarding the need for this to occur. So this was critical recommendation number two. Recommendation number three, York County Prison should restrict SORT usage to higher risk engagement with inmates. SORT had become, as you see here, taken directly from the report, have become the easy button. Difficult or challenging areas, we're having SORT brought in. These are situations, though, that are within the ability and control of the COs that work in the facility. They have the ability to go ahead and execute what needs to be done in these situations. When you call in SORT, you are calling in specialists. They should be reserved for those specialty situations, high risk engagement. And before you do such an activation, one of the things that should occur is number four. A negotiator, de-escalator, and CIT, the crisis intervention teams that we talked about many times, they should be activated at all times prior to SORT activation. By summer of 2023, we had, I believe it was, and it's detailed in the report, I believe it was over 60 corrections officers who were CIT trained. They do go to our CIT academies, and it's very important to have. This was also stressed as part of the report into the death of Everett Palmer Jr. And this is something that Mr. Wetzel has talked about and opined on extensively. The critical need for this. You must engage in de-escalation through de-escalators and CIT prior to engaging SORT and prior to having higher risk and higher degree of involvement on the force continuum from your corrections officers. The use of a negotiator, de-escalator, and CIT should be mandatory with potential discipline for noncompliance. It is through potential discipline that you have accountability, and that is an important part of effectuating policy. 5, YCP should continue to enhance its training for all COs. So enhanced training has been occurring. Since 2023, as noted, YCP has enhanced its training in de-escalation, use of force, and CIT. This is especially true for SORT. But YCP must continue to expand this to all COs. This is very, very critical. It is only through training that you become accomplished and are able to carry out what is needed to be accomplished in order to go ahead and assist with diagnosing a problem and carrying out the proper solution. Additionally, this training should include identifying why is an individual being non-compliant. There's a difference between an individual being non-compliant because they are intentionally wanting to be belligerent and cause a potential violent scenario, and an individual like Mr. Dixon who's not feeling well and wants to be left alone. The training that is provided should also include ways to further analyze that inability to comply regarding if it's physical in nature, how the physical aspect is impacting, then that way there can be an accommodation that is made, an approach, an interaction, and discussion. Again, what began the tasing aspect? The inability through not feeling well to be able to remove shoes and comply with that order. So it's very important to have that go forth to the corrections officers. Number 6, the use of force policy should remove taser deployment from level 2 and emphasize taser is not an appropriate tool for compliance. In the use of force policies within York County Prison, level 2 has a lot of different aspects to it in terms of what you can do in the use of force continuum. And they go from things as simple as use of simple physical compliance aspects to including taser. And there's nothing distinguishing between this wide array on the continuum. Taser usage should be elevated to being higher than these other methodologies, given the seriousness and the nature of taser. And it should never be used for compliance. That was something highly recommended by Mr. Wetzel. Warden Ogle had discussed some degree of concerns. He did not want to have a chilling effect occur regarding if a CO then legitimately needs to go to taser and can't go through other methodologies before doing so due to risk of harm to himself or others. He didn't want them to not have that, feel that they have that option. However, this past year, there was an order put forth that has in fact now elevated use of taser to being higher than the remainder of the level 2 uses of force. And that has been deemed necessary and is continuing to be developed to be established as part of permanent policy beyond working orders at this point. So that recommendation is in process of being carried out. YCP should modify its policies concerning ERC use. The emergency restraint chair usage is very frequent. The emergency restraint chair does serve a purpose. However, there are times where through de-escalation and other movement, you could accomplish what was necessary without using an emergency restraint chair. The modifications should be most important to ensure that 1, de-escalation techniques are always employed before use of an ERC, and 2, that medical clearance is given for use of an ERC in order to avoid health issues associated with physical restraint. And then, if there's a violation, it should fall on the disciplinary continuum. Number 8, mandatory discipline should accompany violations of use of force policy. In this particular instance, Mr. Wetzel opined from his review that CO number 1 did violate the use of force policy. There were reviews conducted within YCP by YCP leadership, and there was the recommendation to the warden that there was not a violation of use of force policy because then existing training aspects coming off of the interactions with consultant number 1 did not create a use of force policy violation in their opinion. However, there was a violation at the very least in failing to call out the use of taser and employing the taser while another CO was holding on to Mr. Dixon. The ramification off of this was, in fact, by Warden Ogle, the ordering of increased training for CO number 1. And that training was then conducted with all members of SORT to not use taser in the manner and as often as it had been used, not using it for mere compliance. The issue of reasonableness, and in the mind of Mr. Wetzel as he opined, that CO number 1, his belief that he needed to use it based upon slight movement of Mr. Dixon, that was unreasonable, but also potentially showed a fear-based aspect based upon the evidence and statements by CO number 1 in terms of the approach of working on SORT. All of which would increase taking a look at a situation that may be unreasonable and in your mind making it reasonable. All of this means is that if you have use of force policy violations, the investigating grand jury strongly recommended there must be discipline. It cannot be something that is wavering. It must occur because that will increase compliance. However, it can only occur after assuring that COs are properly trained in the area for which they are subject to discipline. That will always be a key component. Number 9, all contract provider number 1 policies must be available for training and review within YCP, regardless of whether they are applicable to all facilities or specific to YCP. That's a change that contract provider number 1 should do with all facilities for where they are contracted. And that's something that should be required for any medical provider. This confusion that existed over a basic medical policy absolutely was part of the harm that existed to Mr. Dixon. That cannot exist. So that is a strong recommendation of the investigating grand jury. Number 10, decision-making responsibilities must clearly be defined between medical and correction staffs. There were numerous areas where, especially on matters such as should an individual be placed in a segregated unit, or should the use of an ERC occur, where medical staff and prison staff were each looking at the other saying, well, that's their decision. That shows that there were not clear lines drawn for who holds the ultimate authority in a given area and under what circumstances they should exist. That must clearly be drawn for all medical and correctional staff to be able to carry out their critical functions and duties. Those must be written clearly in policy and then trained to each individual. Number 11, the charge nurse for each medical shift must at least have the qualifications of an RN. This is not to diminish the important role that LPNs play, but LPNs have less ability to carry out certain medical duties and have less demand placed upon them for training and experience than an RN. Having an RN be the individual who is responsible as a charge nurse can increase awareness of what's going on in a medical situation, which would then increase the awareness to make calls and contacts to other individuals, such as providers, outside doctors, and physician's assistants. And finally, number 12, the legislature should enact a criminally negligent homicide statute. We have criminally negligent homicide equivalencies for criminal negligence in other areas. For instance, homicide by vehicle while DUI, that has as a mental intent criminal negligence. Careless driving, unintentional death, even though it's a summary offense, carries with it a mental intent of criminal negligence. Other jurisdictions like Utah, and we specifically reference those two cases, they carry with it statutes regarding criminally negligent homicide. That should be something that we have the ability to consider and review in Pennsylvania. It's a question of accountability. Involuntary manslaughter, which requires recklessness and or gross negligence, that's a misdemeanor of the first degree. Clearly something involving criminal negligence as a general statute would be lower. Misdemeanor of the second degree, misdemeanor of the third degree. But right now, there's no accountability for that kind of conduct to even consider whether it's appropriate. And even if it's only a misdemeanor of the second degree or misdemeanor of the third degree, it still is accountability. It still signifies that something that was criminally negligent occurred and was a direct and substantial cause of another's death. We need to add that in Pennsylvania. Those are the basic findings as well as the recommendations of the investigating grand jury. This is a very lengthy and thorough report. Again, we weren't going to go ahead and read everything. We leave it to everyone else to read all the materials and items. As is, in doing a brief review, it took a long time to cover such ground. This was 2 years of intensive work by an investigating grand jury. This is truly a community opinion and does serve as the great companion piece to the work that was originally done with Everett Palmer Jr. This work also, as a final point, shows as well that the York County community takes every loss of life seriously and recognizes and acknowledges the true dignity of every living person, of every soul, of every individual. The fact that Mr. Dixon may have had an arrest and been committed to York County Prison does not mean that his death was unimportant and should not be treated with the respect and the dignity it deserved in having a full and fair investigation. While the results in this investigation did not merit charges, it did merit critical recommendations for how we can better serve our inmate population in York County Prison, how medical providers can better serve that population, how we can have changes to the law, and additionally, through the assistance of individuals like John Wetzel, convey that as being the standard course of conduct, not only throughout York County, but throughout Pennsylvania. We have done great work in York County. There is great work that has been accomplished in York County Prison. This incident highlighted the need to continue to review that work and continue to go forward. And the community saw fit, and rightfully so, to make sure that there are standards and recommendations to be considered and followed. And that is exactly what this report is being offered to have done. And we are confident that we will continue to grow and be a shining example of how community corrections can and will be conducted to serve the best interests of public safety, community well-being, and fairness and justice. With that, I'm going to turn the attention over to Mr. Wetzel to make a couple comments regarding the importance of evaluations like this and what he has seen in the course of corrections.
Yeah, and just real briefly, I've done 2 grand juries in my life, and they're both here. And I don't think it should go unnoticed that you have a circumstance where somebody tragically dies inside your jail, and rather than hide it or rather than make up some excuse, you get a bunch of citizens to dedicate 2 years to ensure they understand what happened and make recommendations at what should continue to happen. And I just really want to note that, especially in these times when we're focusing on all kinds of stuff and we're jumping to conclusions. Nobody's happy that this happened, but I continue to have a lot of respect for York County, the District Attorney's Office, the Prison Board, to really tackle these complicated issues. My nonprofit is releasing a national report tomorrow on the correctional staffing emergency at the state level. These facilities are key parts of the community. You guys recognize this by doing a grand jury, and they're in crisis. And so I think it's really critical, and it's worth my time and all our time to really rally around, pull a community together, and figure out what we as a community deserve. What do we demand from our system? And I think this is an example of how you do that in a really cool way. And so I'm just happy and honored to be part of it.
With that, we'll take some questions, and again, I can only answer within the scope of the redactions, so please do not be disappointed if there are a bunch of comments I make that are going to be like, I'm sorry, the law required that's redacted, but we're following the law.
I'd like to ask both of you, this within the context of acknowledging that, as you said, a lot, it sounds like, has already changed even before these recommendations. That said, comparing this to Everett Palmer Jr., if anything, in that case, you had the questions about what substances might have been at play and so forth. Just sort of, and also without the benefit of, that was 5 years ago, and this I've just for now, just recalling everything. I mean, this almost sounds like maybe a clearer cut case of just somebody who would have survived had people done things differently in prison. Just your thoughts about that, either of you. If in some ways, small sample size, just 2 cases, but things almost regressed over those 5 years.
I don't think regressed is the right way to put it. I think that there were different circumstances, each that had specific prevention points. Some of the things that were prevention points with regards to Mr. Palmer were also things that were occurring outside of what occurs within prison walls. If you remember all the recommendations for criminal justice initiatives, investments to be made overall, whether or not there should be different diversion areas looked at, such as with the setting of bail, what we should be investing in with reentry, how we should be looking at substance use disorder, at mental health issues in general, things of that nature. In Mr. Palmer's case, the high-risk extraction carried out by CERT, which is what it was called then, that high-risk extraction, there absolutely was to a T within policy and carried out the way that high-risk extractions are to be carried out. The number one issue that could have possibly prevented some escalation to that point would have been a recognition that there was methamphetamine toxicity that was occurring. It was assumed that this was a product of mental health condition, not of a drug-related condition, because none of that information was in the possession of the prison. So a lot of what was going on then was a complete deprivation of prison information to go ahead and carry out certain steps. And if you recall, there were a lot of aspects of that were included in the recommendations. Now, there were also recommendations that were included because since you don't know what you don't know when you're encountering people regarding use of taser, regarding use of other de-escalation aspects, different things along the way. Because in that case, the use of taser, the nature of the high-risk extraction then may have exacerbated the withdrawal from methamphetamine, the methamphetamine complications, the delirium state, the delirium tremens that were being experienced at that time. Here, that's different. You don't have the substance use disorder aspects. There's also something that is a relative unknown, which is that there is a blood clot. However, there are a number of knowns. And the question in this case is, how did the interactions occur surrounding the knowns? And that was something that was different. Because they did know that Mr. Dixon had diabetes. They did know that Mr. Dixon did have hypertension, did know that there were cardiovascular concerns to have. So from that aspect, this is, other than the last recommendation made by the investigating grand jury, this is a very specific, this is what we recommend you need to do within how you conduct yourself as COs and as medical staff. And if you change this, you may be able to preserve life. So it is different from that aspect. Everett Palmer, a lot more external issues and information deprivation. Here, one key component was missing, the clotting issue, but there was also information provided, and that information was either not properly evaluated or not properly considered, and there was conduct within the prison that, if we change, could increase likelihood of survivability.
I think I just say real quick, I think in the Palmer case to now, I know significant progress. And I think one of the things I'll put a fine point on is you talk about culture change, and in the midst of culture change, so data showed that they were making progress, but that culture change is taking place at a time when you don't have the resources, you don't have the staff. So things like training, it's hard to pull people and impact and pull people, like you can't pull 30 people off a shift to train them. So I think this occurred, I mean, it clearly occurred at a time of transition and things were improving. So in some aspects, I can sense that some frustration to say, well, I thought we fixed this. There's been significant progress. But in this point in time, as you know, there was a lot of circumstances that were under the control that if had someone acted differently, would have been in a better position. Not necessarily, we don't know what the outcome would have been because of the nature of blood clots, but certainly could have been in a better position.
Yes, I'll keep going from right to left. Yes.
What is Mr. Dixon's death being ruled as? Is it, accidental? Is it natural causes? What is being?
So that will be up to Coroner Zek. So she has the report, and she just got the report yesterday because we were able to, since it's now filed, the redactions were completed, approved by the judge. Now we can go ahead and we can transmit that over. Given the length of it and the seriousness of it, Coroner Zek will be going through this and then make a determination. We don't know what that determination will be at this point, but there is definitively information in here that will allow Coroner Zek to see if she can make a determination. It may wind up, given all the facts and circumstances, that there still could be an aspect that's undetermined. But that will be up to Coroner Zek, and she'll let us know as soon as a decision and as soon as her review is now completed. Yes?
Are you saying that excessive force was used on Dixon with the taser?
So there was a violation of the use of force policy. When you have a violation that way, that can be deemed as excessive. That is what the conclusion of Mr. Wetzel was. That was also what the finding was by the investigating grand jury in going that way, that there were violations that occurred. And when we talk about excessiveness, one of the aspects that I think we need to understand with excessiveness is whether or not an action was reasonable under the circumstance. Without there being any de-escalation techniques being used, when you have COs talking over each other, when you have the lack of further movement and you have subtle movement, and that appears to be, now I'm perceiving danger that I must employ a taser, while these will be judgment calls. You look at, well, was it reasonable looking at everything? And Mr. Wetzel, clearly opined that it was unreasonable. There were aspects of what occurred as well that I think all agreed that were not reasonable. That included the, not alerting that they're using the taser. The CO still holding on to Mr. Dixon. And it begs the question then, well, why did CO number one believe the actions were reasonable? You can think something was reasonable and have it be unreasonable based upon whether or not you did not have the proper training, culture, what was then existing in terms of what's occurring. So when we say excessive, we're talking in terms of unreasonable for the circumstances, since all of these other matters did not occur and did not take place that should have within the scope of the training and knowledge of CO number one. So I wanted to clarify that because there are a lot of times, and the report really talks about that, like when we think of excessive, we think of like what was the direct harm caused. And one of the issues that gets discussed in the report, it is a known the role that tasing plays in situations like this. Like there is not, in terms of the science, it's not definitive like you're tased, therefore the following happens to you, especially if you have a blood clot. There are varying factors that go into play. All of that's referenced within the testimony. But just because you may not be saying an individual harm lined up directly to an application, it also does not mean that the action was reasonable. It can be unreasonable, which then makes it excessive.
Being that Dixon had a pre-existing health conditions, do you believe the force aided in his death?
So the conclusion of, and I'll go with what Dr. Sterling Roney said, he made sure to mention about being incarcerated and restrained as the condition. And it is not the cause, but is the underlying aspect of what Mr. Dixon was being subjected to at that time. So it's not like if we say cause of death, gunshot wound. That's easy with that. But when you're talking about a natural circumstance in terms of a blood clot coming to the lungs, the conditions he found himself in, Mr. Dixon found himself in, are important to note because they can exacerbate what was occurring with the clot. And that is the scope of what Dr. Sterling Roney was saying. And he talked, and in the investigating grand jury report, they talk a lot about how those can contribute, what the exacerbation can be when you have a tasing and you have an emergency restraint chair situation. So definitely they were noted to be an exacerbation of the condition, to be included as an underlying aspect of cause of death, but it's not like gunshot wound. It's not that type of cause of death.
Okay, will the officers face any consequences, or that's to be determined?
So no, so in terms of any criminal consequences, there are no criminal charges that are applicable in this case. That's what we were talking about. If there would have been a presentment that was done. So no, there are no, the facts do not meet the elements of the crimes.
Well, not criminal consequences, but what about other consequences? Employment consequences?
So
Civil consequences?
in terms of anything like that, I don't speak to personnel matters. That's not anything I speak to as to what they would be, how they would be, or anything like that. Regarding any of the individuals, I can state that regarding nurse number 1 and nurse number 2, they were separated from their employment. That's contained within the report. In terms of any further actions for anybody else, that again, there were training requirements that had occurred for CO number 1. All of the SORT members did receive further training requirements as documented in the report. In terms of any civil actions or civil liability, I believe it was reported before that there are civil actions being pursued by Mr. Dixon's family. And so that any aspects like that would be for them to speak to or to comment on. That's not something that, and not the purpose of a grand jury report, to comment or to do anything in terms of civil action or to do anything in terms of liabilities or violations for employment or anything of that nature. It is to go ahead and see what happened, what occurred, what are the underlying facts, and do they support any recommendations. Yes, sir.
The words redacted files have dominated our headlines nationwide. And obviously these two cases, no relation. So are you worried when the public hears you say redacted files that this report will be met with reluctance, suspicion, or even some caution?
No. And I want to tell you why I'm not concerned whatsoever is because, number one, it's the law. I can't worry about those things. We're to follow the law. I'm to follow it. Our office is to follow it. The investigating grand jury is to follow it. The court that approved the filing of the report has to follow it. We all have to follow the law. The second thing is there is nothing in terms of this that is meant to hide or conceal, quite frankly. The facts are what they are. Just to, not to reference any old TV shows, but the names are changed to protect the innocent. In this case, they are changed to protect individuals who have a constitutional right of reputation. They have that. Everyone has that. And the exact same thing that we are showing every individual here, regardless of role, regardless of scope, is the exact same thing that we'll show to every person that comes into contact with our system of justice. It's in Article 1, Section 1 for a reason, right next to life, liberty, and property. It's because that's what the framers of our Pennsylvania Constitution determined the right of reputation to be. That important, as important of anything we have. And our Pennsylvania Supreme Court has reaffirmed that as recently as 2024, that it's that important. And if we violate that, then this whole report, all this work, all the recommendations, the whole thing would be ordered to be sealed and nobody would know anything and no recommendations could be made. And it would be as if 2 years of critically important work didn't occur and didn't exist. That's why you better believe we are redacting, because we got a real purpose for being here in line with the purpose of a report. There are administrative, executive, and legislative changes that can be made, and there is important work. The important work that John Wetzel's doing. This helped show why this important work needs to continue and what the policy implications are. So I have no concerns whatsoever because what we did is a pure following and application of the laws of this Commonwealth.
I think it also, it's a grand jury. Hold on 1 second. It is a grand jury. So it actually, the citizens who were in the grand jury, it wasn't redacted for them. So they got the information.
Yes.
So this isn't public officials just saying it. This was presented to citizens. They asked questions. They asked followed up. So the redacted portion refers to what is publicly reported for the reasons as enumerated, but the conclusions were from the people. I think that differentiates a little bit from what you were saying. I just wanted to clarify.
I don't want to belabor the point on redactions too much, but I just want to make sure that we all understand that
Was it the court who was suggesting redactions and then implementing them, or was it your party as a party to the proceeding suggesting certain redactions? I mean, who kind of held the pen if you blacked out the writing, if you don't mind the turn of phrase?
How the process goes, you produce an original report that's unredacted. That unredacted report is what is reviewed and decided if this report produced by the investigating grand jury that they go through, they review, they look at everything, is decided by them. Is this our report? They submit it. It's unredacted. Every name used, mentioned, nothing blacked out, the whole thing. That gets submitted to the court to determine whether or not it's factually accurate, and going through to see if it is, to see if what was presented before the grand jury supports what is stated in the grand jury report. Then following that, and because we know from case law and experience, redactions are going to be necessary, we then prepare redactions for the court to review, to see if what then will become public is sufficient and appropriate under the law. If there is no sufficient way to redact this report, then the report must be put under seal and no one can ever review it. If you can successfully redact and protect rights of reputation through the case law, which the Supreme Court said is a court function, the statute's silent on this remedy, but the court has determined it's a remedy that they can employ. They have the remedy of seal and the remedy of redaction. And that is expressly what they ordered the Attorney General's office to do in the 40th statewide grand jury. They ordered them to go back and redact before they released. And then the AG's office had to redact subject to court approval. So knowing that that is the state of the law, that is what gets undertaken. And then once the court approves, then an order for filing occurs. And the order for filing that will occur orders that an unredacted report is always sealed and a redacted report is available to the public. So, yes.
A couple rapid fire clarification
Sure.
questions for you. Do you know how long Dixon was in YCP before this incident occurred?
Yes, he, I believe, went in on, was it the evening of July 4th? I know he was arrested on July 4th. And I think maybe on the 5th was actually when he went in with the commitment. It was, I believe it was the 5th was when the commitment occurred and he was transported to York County Prison. So, and his death, the time of death being after midnight was July 7th. Most of the actions we talked about occurred on July 6th.
And you had mentioned earlier Nurse One's response time. Did you mean when the medical emergency was declared, or was that in general for the lack of medical attention?
So when I was talking about responsiveness, so there are two times that I did talk about. One aspect of response was when a medical emergency was declared, here was the time, and went down. I did also mention the exact time when on the first check at Seg B, and again, I apologize so much, when Nurse One went to Seg B and had the exchange with Mr. Dixon. But in general, response times, when we're talking about them as a general consideration, that is in terms of if medical care had been delivered earlier, if it had been delivered, say, even as recently as when Sergeant Number 1 came and reported the medical condition of Mr. Dixon to Nurse Number 1, that increases even the probability of survivability at that point. It cannot be excluded that there would be survivability, even though you're only talking about like a 13-minute window to 15-minute window and around that range, the range that I stated before. If you go back even earlier with response time in terms of medical care, back to when coming in for the tasing and the ERC, or even before that, if there was a complete medical evaluation, like John Wetzel had talked about, and you'll see in the report, had it gone back even before that, clearly you increase your survivability even greater. And so in that aspect, when we're talking about response times, we're talking about medical care delivery as a response.
Two more quick ones. Who determines the conscious disregard when it comes to criminal charges?
So in terms of submission of that to a grand jury with whether to seek a presentment, that's determined by us. And that's why in there we include a statement by the Office of the District Attorney. We did the same thing in Everett Palmer Jr.'s case, and we did the same thing here. We ethically cannot put something for consideration for a criminal charge before a grand jury if we know that there's not probable cause, let alone if we know we can't meet the standards of prima facie or beyond a reasonable doubt before an investigating grand jury. So because of that, we followed our ethical responsibility, did not present it, but we also needed to provide that explanation to the investigating grand jury, and then it becomes important to attach to the report to know this determination was made by the district attorney's office, ultimately by me as district attorney, and this is the reason why we are not able to have a presentment, and this was not a consideration for the investigating grand jury, and this was solely a report now that was being considered.
And final question is just, you sort of mentioned how some of the recommendations by the grand jury have already sort of been worked on or are already in place. If you could give a percentage of, like an estimate of how far the YCP has come in those recommendations being implemented, or if there's a future timeline for the rest of them.
Sure. So prison board and prison leadership didn't know what was in these recommendations. While I am on prison board, by law, I cannot tell anything that we were doing to prison board, and I did not tell them a thing. Couldn't do it, wasn't allowed to. All the actions that were being undertaken through separate reviews of things that were going on, and we're working on a timetable separate from having these recommendations. Some of the matters that were already being worked on are, quite frankly, very far along, almost at total completion. Other matters were gradually happening as part of what the gradual aspects were, such as the training, the education, things like that, and were all naturally occurring since the time of Mr. Dixon's death. Some aspects, including demanding to be a performance-based, having performance-based medical provision within the county, that is something that is additional and would satisfy as well what some of the recommendations were. Other aspects, clearly, like speaking with members of the legislature, that did not occur and could not occur until now. So they're at varying aspects because now the recommendations are there. With these recommendations, they're going to have an impact of changing and altering timelines and factoring it into other areas and other aspects.
What guarantee is there that these will be implemented? Like, how do we, I hear you, but how do we know these will be happening? Because you had a bunch of these 5 years ago.
Yes. And
you had a contractor who went over Opal's head and actually went against one of those recommendations and advocated for more taser use rather than less taser use. So how do we know that these will be done?
well, the only way that I can tell you that we know that they'll be done is because they are going to be a requirement. That's all that we can say, and that they're going to be put in place. And again, one of the aspects, when you look at the original recommendation that it existed off of going away from taser usage from the Palmer report, I'll use this as an example. At that point in time, there was a belief also that the foam could go ahead and would be safer, more secure in given circumstances. However, subsequent to that, there became an issue involving foam. There became an issue involving other ways. And there were modifications that occurred with tasers. So if you take a look at the Everett Palmer death investigation report, and you see a recommendation to end use of taser, you'll wind up going ahead and seeing that the alternative recommendation actually wasn't lining up with some other things that need to be done given what was occurring within York County Prison. And these are only recommendations from the investigating grand jury. They are not chapter and verse in terms of the details. That is beyond the scope of what lay citizens could go ahead and be able to state. They are generally, though, very accurate based upon a foundation of fact. They're in line with recommendations given by John Wetzel. And one of the things that you do in the course of management is when you see something that is not occurring in the way that you thought it would with what be occurring, you change and you alter course. That occurred in York County Prison. That occurred definitively, and as it was occurring, you take a look at how much the taser reduction has occurred. So to say that, well, nothing was implemented for 5 years, that's patently wrong. It did. If you look at the taser implementation from the statistics I just read, when you're looking at where they were in 2024 and 2025, when you look at use of force in 2025, in high-risk extraction, they were greatly reduced. When you look at the number of individuals that are de-escalation trained and CIT trained, they have continued to dramatically increase, and especially since the time of the Palmer report. And that was specifically noted and why John Wetzel commented on that. And quite frankly, Mr. Wetzel has a very strong and great reputation around this country. Do you think for a one moment that, number one, he would have entertained being our expert, number two, stand here next to me talking about this and what's in this report, if he did not believe that we are a county that researches, follows, and seeks to implement everything in the best interest of inmates, he would not be here. And I wouldn't ask him to be here because it would be an insult to the great work that he's doing. So absolutely, I can tell you that these matters are going to be strongly considered, have a form of implementation with everything that we're already doing, and we will achieve greater degrees of success and preservation of life. And with that, I think I took a question from everybody in here, and I take a look and it's after 4 o'clock. So since we've been here for 2 hours, I think it's time for us to call it a day. The report is a public record now, so it is something that can be obtained. And I thank everybody greatly for being here, for listening to this. I know it was long, but this is important, very important, critical work that occurred within our community, by our community. Thank you.